thanks for the invitation to be here. And hopefully you can hear me. Can you hear me in the back? You can hear okay? Okay. So I'm glad you're here today, and it's good to be with you. How many of you have heard that 2-minute program that airs daily? There is a Wichita station that carries it. It's a farm radio station. I can't remember the call letters or the frequency. It's also I'm also on Sirius XM, and they run that at an average of about 6 to 7 times every 24-hour cycle. I personally have never heard it on Sirius XM. My wife has. She called me one time and said that she had just heard it. So that was the good news. She said the bad news was that they aired you between the 4th and 5th heats of the chuck wagon races in Saskatchewan, Canada. So I guess you made it big when you're between the heats of the chuck wagon races on Sirius XM. But we got a lot to cover today, and we won't have any problem filling the time, and hopefully it'll move fast for you this morning. But I do want to show you what we do at the law school in terms of trying to deal with a problem across the country of the lack of attorneys in rural areas, in the Plains and in the West. And one of the things, I go from here to the state FFA convention at K-State tomorrow, and then a meeting with the directors, the production engineers at RFD TV. We're working on a series of programs that may turn into a documentary on this whole problem of rural people not having adequate legal representation and what we're trying to do to solve that problem at the law school. This is just a list of the various classes that our students can take that touch on agriculture. And of course, I teach the capstone course, which is agricultural law and policy, which is the last course that they take before they sit for the bar exam. And they can't take all of these at once. These are on a rotated basis, but hopefully over their 3 years, they can get several of these courses that would be of interest to them. There's a lot of those. And if I showed you what the other law school in Kansas teaches, the next slide would be blank. They have 0 with respect to that. They have no intention of ever representing or trying to service the state of Kansas beyond west of Topeka, basically. And that's what we fill up. We are the law school for the state of Kansas, and we are making a concerted effort to make that point clear. Well, let's start with various topics today, which are of importance to all producers of any size, and then we're going to get into specific issues with specialty crop producers and urban type producers. But a lot of the issues that you're going to run up against, you're going to find are more prevalent in the rural urban fringe areas. I've done a seminar like this, unique to kind of niche producers. I did it in Colorado a couple of years ago. What do you imagine was the niche crop that they wanted to talk about out there? Cannabis, marijuana, yeah. And hemp, yeah. A lot of unique issues associated with that. And then, of course, I deal with the accountants and the CPAs that prepare the tax returns for those people, which refuse to sign the tax returns because they don't want to get in trouble. But their clients, they say, I'll pay in cash, which is interesting. Okay?
Why the IRS requires you to report illegal income.
Uh-huh. And that's an issue that we deal with. You have a federally controlled substance allowed at the state level. Now, isn't that an interesting legal conundrum right there? That'll probably change in coming months. In fact, it's Justice Thomas on the U.S. Supreme Court that issued an opinion a couple of years ago, and he said, I'm tired of this discrepancy between the states and the Fed. Either go one way or the other, but just pick a side. Because we can't deal with this different legal system at the state level and at the federal level. Now, when we get into rural fences, there are a number of primary issues that we deal with. And fence issues, I'd say outside of tax and estate planning, the biggest areas of questions for me that I get from people that I have to deal with and that I write about and address have to do with fences and leases. We're not going to talk about leases today, we'll talk about fences. And there are a number of issues, and this is just kind of a summary slide of what the major issues are. And the first question has to do with partition. What is the partition? And what does the term partition mean? Constructing and maintaining fences, What's that all about? What are the rules in Kansas? What happens if animals get out? Who's responsible for damages with respect to damages caused by escaped livestock? Who are the fence viewers and what are their duties? What are their obligations? And how do you handle stray animals? Those are some of the major issues that we deal with concerning fences in rural areas. Well, first of all, a partition fence. What is it? It's a boundary fence. That's what a partition is. A partition is the boundary line between your property and an adjacent landowner's property. And that is to be placed, the partition fence is to be placed on the line between tracts of land owned by different persons. So partition means boundary. And so we want to start with that principle. But it can be located entirely on one side of the boundary. Why? Well, there are some basic reasons for that. It may be impractical to put the fence where the surveyed boundary is, so we set it off of there because of just geographic concerns. We just can't put a fence through there. It's dense brush, it's rocks, it's a water gap, and so we just set the fence off of the boundary. Well, if you do that, that can create issues potentially down the road, and we'll talk about that. And that fence that's not actually on the partition can become the actual boundary after a passage of time, depending on how the parties have used that fence. And again, that can happen over a passage of time. We'll define what that time is. And the adjacent owner has, over time, come to believe that the fence marks the boundary. Or you've had a change in ownership on the other side of the fence and nobody checked, that owner didn't check and just presumed that's the boundary fence. And then lo and behold, somebody has a survey done down the road and discovers, well, that's actually over on them. What do you do at that point in time? Well, if that fence has been there long enough and it's been treated by the adjacent owners as the boundary, then because of that passage of time, it can become the boundary. And it doesn't matter what the deed or the survey says. And that's an important point because in rural areas, more often than not, the location of the fence and the usage of the fence determines the boundary more than a survey does. And that's hard for urban people to understand. Okay? In ag, and that's the point I'm making, usage of property may determine the boundary more often than a survey. How has it actually been used? Have the parties used it long enough and have treated it as the boundary? They never really knew where the boundary was. They just made an assumption, that's the boundary. I've farmed up to that on my side, or I've treated it as the boundary on my side, my neighbor's done the same thing. Then you have a survey later on. The survey may be meaningless because you can have that fence established as the legal property boundary by court action. Okay, a concept related to that, I'll come back to that in a moment, but related to this passage of time issue is the notion of adverse possession. You've heard of adverse possession, right? Okay. What's a common term, a different common term that is used to describe that?
Squatting.
Squatters' rights, yes. Have you seen the news stories that came out this spring out of New York City?
Oh, yes.
Wasn't that incredible? Yeah. What's this person doing here? Yeah, get out of my house. And then the one lady got arrested for trying to take possession of her property that somebody else had squatted in. But that's what this whole concept is. It's an old English concept that's carried over into the United States. It's known as adverse possession. And what adverse possession says is that a landowner can acquire title to property by making an open and notorious use of the property for 15 years. Now that's different than what I just talked about a moment ago, where we just assumed a boundary, we just assumed a fence was on the boundary. We didn't really know where the boundary was. Adverse possession is where I know I don't own that. I know I don't own that strip. But I'm going to go ahead and use it anyway and see if they boot me off of there. And if they don't, then I'm basically squatting on their property. That's where that term comes from. And if they don't boot me out within a certain period of time, then I can claim ownership to that by adverse possession. I have adversely possessed somebody else's property, knowing it's not my property, and they know that I'm there and didn't do anything about it. Okay, that's what adverse possession is all about. Now, Again, this is the summary of what I just said. Applies when the adjacent parties know, and the italics here is very important, know the existing fence is not on the boundary and one party is benefited by the misplaced fence. We know it's not in the right spot. But I don't want to say anything to my neighbor. I don't want to upset them. I want to get along with my neighbor. Well, that can lead your neighbor then eventually, if they get to the 15-year mark in Kansas, and you can tack on a previous owner's usage in that same fashion to your time of ownership to get to the 15 years, and just by being nice, you can lose some of your property. I had one of those cases in Geary County within the past 2 years. It was an elderly landowner, big rancher, very prominent in the area, and they just decided, we're going to take a couple acres of this. We know it's not ours. She's not going to object. We're going to tear the trees out. We want to farm that. And she kept trying to talk to them and be nice, and said, I don't want to upset them, and I'll say some things here and there, but she never said out. She never enforced her rights, and they ended up taking it. But she got rolled on, is what happened in that situation. So to adversely possess a property in Kansas, you have to openly, exclusively, and continuously be in possession of the real estate, knowingly adverse to the true property owner. So what word in there do you see coming up over and over? Knowingly, knowingly. Okay? You know that the fence is in the wrong location. You know your usage is adverse to the other owner, and you continue to use it. And the owner knows that your usage is adverse, and they didn't do anything about it. That's the key to adverse possession. And I'll contrast that with another concept here in a moment. Let's look at a couple of cases. And over the past 2 or 3 years, we've had several adverse possession cases go to either the Kansas Court of Appeals or the Kansas Supreme Court. And they can arise in different contexts. And some of these are farm cases and some of them are more residential in nature. Plaintiffs were and here's your residential case. Plaintiffs were the 8th owners of a home that they purchased in 2003. The house was built in the 1980s. So this house has been sold multiple times. Okay, they bought it in 2003. There was a chain link fence in the backyard installed by the prior owner, a prior owner, in the 1980s. Okay, so chain link fence, backyard, they may have a garden or raising chickens or something like that. At the purchase in 2003, the disclosure document indicated the fence was on the property line. There was no mention of a survey. The fence is on property line, doesn't talk about a survey. Plaintiffs maintain the property up to the fence and sometimes beyond it in terms of mowing the grass and maintaining weed control and all of that. They took out the fence in 2018. Notice they bought the property in 2003. 15 years later, they took out the fence along with the shed, but continued to maintain the property up to where the fence had been. The adjacent owner then requests a survey which showed the fence line encroached on their lot, which they purchased in 2020. So it wasn't in the right spot. And again, this is a new owner on the other side now coming in 2020 and wanting a survey, and now they've discovered for the first time that the fence line encroached on their lot. Okay, now you got the problem. And this is how most of the time these cases arise. They brought a quiet title action, which is the legal action in court that this is called, to acquire title by adverse possession. So they are seeking to have the court give them title to that disputed strip. Okay? Claiming title by adverse possession. Trial court said, no, you didn't have any reasonable belief of ownership. And the appellate court said, that's right. They knew there was no proof that the fence marked the property line due to a lack of a survey. They only had constructive notice. They had some knowledge that the fence line might not be on the property line, but that wasn't enough. You have to have actual knowledge. That knowledge component is very important to adverse possession. Okay, then we go to Pyle against Gall, another case in 22 that went to the Kansas Court of Appeals. You had a disputed boundary line, and this is a farm case. The plaintiff routinely planted crops up to what they believed was the line, but that interfered with the defendant's tenant and his crop farming activities. Okay, so there's a line, there's not necessarily a fence, but they farmed up to a line on both sides. The plaintiff also used a portion of the defendant's field as an access road to the plaintiff's field. Okay, so now we've got an easement issue and a potential adverse possession issue tied up in the whole thing, in the same event here. The defendant said, all right, I just want to be nice. I will sell you the disputed area. I'll just sell you that area. Let's be nice about this. I'll sell you that. And then told the plaintiff, stop accessing your field by my field. I'll just sell you that so that it's yours. Okay? Sounds like a reasonable way to resolve the dispute. So what do you think the neighbor said?
Mine, I ain't mine.
Right, I don't have to pay for this. I'm going to take it from you. That's exactly what, you've got that neighbor? Yeah, maybe? Okay. Each party hired surveyors, but they reached different conclusions as to the property line. How about that? The surveyors couldn't agree, which raises another issue that I may or may not address later on. The next spring, so let's remind ourselves who the parties are here. So the plaintiff is the one that's encroaching here, and the defendant's trying to be the good person. I'll sell you that property. The defendant builds a fence on the property line according to his surveys. And enough of this, I'm putting up a fence according to what my survey said, which was 17 feet onto what the plaintiff believed was the property line. So 17 feet beyond what the plaintiff believed was the property line. Of course, the plaintiff is upset. So the plaintiff sues to quiet title to the field up to the crop line, claiming that by adverse possession. And he said, I should get an easement also because you can't cut me off the access that I have to my field. You can't cut that off. Okay, so we've got two issues before the court. The trial court said, yes, the plaintiff had adversely possessed the disputed area and had acquired an easement by prescription, meaning the law will imply an easement for you to get to a landlocked tract of land, for you to get to your house or to plant a crop in a field. And the trial court gave them both. And the appellate court affirmed on the adverse possession issue. Met the timing requirement, had the knowledge requirement, had all the requirements satisfied, but reversed on the prescriptive easement issue because they said, well, there's no exclusive use here, which is a requirement. The appellate court thought you had to have exclusive use with respect to the easement. Nobody else could use the easement. You let other people use it. There were other people using it. You weren't the only one. And so they sent the case back to the trial court on the easement by necessity issue because the trial court had never considered that issue. Well, this eventually gets to the Kansas Supreme Court. And they reversed. I had written an article on this before the Supreme Court put out their opinion. I said, okay, that might be right on the adverse possession issue. That's not right on the easement issue. There is no requirement in terms of exclusivity with respect to a prescriptive easement. There is with respect to adverse possession. There is not with respect to an easement issue, and that's what the Supreme Court said. There is no exclusivity requirement as to the public, exclusivity as to use only, meaning they're only using the easement to get access to a field to plant crops. It doesn't matter who the people are that are doing that. It's just used for a singular purpose, exclusive purpose. Okay? Now, on this tacking issue, can I add on somebody else's period of usage to my period of usage to get to 15 years? The answer is yes, with the right circumstances. Okay? In the Shelton against Chaco case, now this is also in 2022, where this hit the Kansas Court of Appeals, the survey revealed the fence was on the plaintiff inside the surveyed boundary. Okay, so the survey's over here, fence is here, it's inside the surveyed boundary. Plaintiff sued to have the survey established as the boundary. I want the boundary over here. I want more property, which I should be entitled to according to the survey. The adjoining owner, the defendant, counterclaimed to establish the fence line as the boundary by adverse possession, saying, no, the fence has been there long enough, I'm going to claim that I get more property by adverse possession. And he won the case. He had 8 years of ownership, plus a prior owner's 7 years in common usage During that period of time, that got it to 15. There was no interruption in the usage, no abandonment. There was a good faith belief that that was the boundary. That was affirmed on appeal because the fence was in place when the defendant bought their tract. So you have to watch those types of things too. That comes up not only in rural areas but also in urban areas as well. Okay. As a counterpart to adverse possession, this is kind of what I started the discussion with, is where you don't really know where the boundary's at. Now, adverse possession requires you to have knowledge of where the true boundary is, and you are deliberately adversely possessing someone else's property without their permission. Okay, that's adverse possession. What I first started talking about is, well, we don't really know where the boundary is. We just use the property up to a particular spot or a fence. We don't know that the fence is actually the boundary. We're just kind of treating it as the boundary. This is known as the doctrine of practical location. Doctrine of practical location. This applies whether the parties know the existing fence is not on the boundary, but don't know where the boundary is located. We don't know where the boundary is. After 15 years, the point is the usage of the fence can cause it to become the boundary. Under what principle? Same theory as adverse possession. Exact same theory, but it's a different route to get there. Okay? We've just used it that way for a long enough period of time. Usage can determine the boundary. And that's why I said earlier, often in an ag setting, usage determines a boundary much more often than does a survey. And it's by this doctrine right here, the doctrine of practical location. So, what if a boundary is in dispute because of conflicting surveys? This issue comes up. Any boundaries and markers set by the first survey control in a conflict with a subsequent survey. And that's true even if there were errors in the original survey. The first survey controls. One of the things you cannot do, and it's a crime in Kansas, is to pull up boundary markers. Don't pull up survey markers. If you think survey stakes are in the wrong place, the last thing you want to do is pull them up. I have had farmers that will do that just to put a crop in the ground. My neighbor had the property surveyed. Now I've got stakes in my field. What'd you do? Well, I needed to plant my crop, so I pulled them up. Don't do that. That can be a crime. You can be prosecuted for that. Don't move those. There are different ways to deal with that issue, but don't touch those. Okay? Now, always consider how the land has been affected by the original survey's location of the boundary. How has the land usage been affected by the original survey's location of the boundary? If the fence is on the old but erroneous survey line and the parties have been farming to the line, don't move the fence because you could end up with a boundary under the doctrine of practical location. That may actually be the boundary. Don't move the fence. That can cause other problems. If the fence doesn't follow either the original survey or the later survey, then you're going to have to designate a boundary line somehow. Okay? That's not what the county commissioners do as the fence viewers. I'll talk about that in just a moment. That's not within their domain. Okay? That's a legal issue right there. Fence viewers don't deal with legal issues. They deal with building and maintaining fences. They don't deal with location issues. Okay? Now, on the issue of building and maintaining fences, how do we do this in Kansas? Well, in rural areas, a lot of farmers will follow the right-hand rule. Sometimes in town, people will follow the right-hand rule. If you're my neighbor and we've got a fence, let's say the table is the fence between us, we just meet in the middle part of the fence. You fix what's on your right, I fix what's on my right. Okay? That's not statutory. That's not what is required by Kansas law. That's just what is common practice as to what's done. What the rule says is it's not halves. What the rule says is so long as the parties continue to occupy or improve such lands unless otherwise agreed, then we share an equal portion of the total cost of building and maintaining that fence. Okay? It's not allocated under the right-hand rule or the left-hand rule. We can agree to that, but it's equal shares. We each bear an equal share of the total cost. Now, that's pretty reasonable. That's a good statute to have, because what might be our problem? You and I meet middle point of the fence, and you're going to fix what's on your right, I'm going to fix what's on my right. Well, I've got a half mile of flat, level, non-rocky pasture, no trees, deep soil, and right at the midpoint is a 500-foot cliff, rocks, trees, water, and God bless you. Have fun fixing your fence. Now, what's going to be cheaper? It's going to be a lot easier for me to build that half mile of fence than it is for her to build that half mile of fence. So that's why we don't follow the right-hand rule. It's an equal share of the total cost that we're going to split. That balances out the cost between the landowners. Okay, now we can modify that by agreement, as I indicated. We can come up with our own agreement. Okay. You can enter also the neighboring land at reasonable times and in a reasonable manner to maintain the fence. It's not a trespass if I step on my neighbor's property to maintain the fence, if that's what I'm doing. That's not a trespass. And reasonability is a fact-based determination. What's reasonable under the circumstances. Now, the reality, as I said, is we often use the right-hand rule. You can also record a fence agreement on the land records. Has anybody ever seen one? I've seen two in over 30 years that somebody actually recorded the fence agreement to bind themselves and all subsequent owners. Issues over at that point in time in terms of how we're fixing the fence, because it's on the land records as to how the border fence, the partition fence, is to be dealt with. Okay? And that runs with the land and binds subsequent owners to that. Now, fence laws and trespassing livestock. What are some of the rules with respect to this? Well, Kansas follows the fence-in theory, and so under the common law, failure to keep your livestock at home subjects you to liability. If they get out, you have a responsibility to keep your animals fenced in. Okay? Some of the western states, when you get out west, Colorado, Wyoming, parts of South Dakota, Montana, and so forth, they require landowners to construct fences around their property to fence out trespassing livestock. So in an open range state or in states that have designated areas, they are fence out. The animals can roam at large, and you have the obligation to put a fence up to keep those animals out. Okay? That's a fence out. We are not a fence out state, we are fence in. And so in a fence out jurisdiction, if livestock trespass within a lawful enclosure, the owner is strictly liable for the damages. That's not a negligence-based approach. If you're in a fence-out jurisdiction, you put up a fence to keep somebody else's animals out, they get into your fence, that animal owner is strictly liable in that situation. So in a fence-in jurisdiction, if I have animals, I have to keep them fenced in. It's unlawful for any livestock to run at large. But this is where it gets confusing in Kansas. There's a limitation to this. There's a limitation. Remember that equal share rule? Okay. What if I have livestock and there's a dilapidated fence between you and I? You don't have livestock. You've got, you're a specialty crop producer, you've got vegetables, you've got all types of things that you're growing, you have plants, you don't have livestock, and I approach you and I said, well, we got this dilapidated fence between us, it's a mile long, you need to pay for half of that. What's your response? No. You know, your vegetables, your crops, your garden things, your plants, they don't have a habit of getting up and walking away in the middle of the night. He said, no, I don't need the fence. You build the fence. I said, well, no, there's an equal share rule. We're supposed to share equally. You need to be nice. And you still say, yeah. Okay, so I've run up against this neighbor that's not very nice. What do? I call the county commissioners. That's what I do, because we can't resolve this. I said, well, she's not nice. And what are the county commissioners going to tell you to do? if they're doing their job.
Go back to the neighbor.
What?
Go back to the neighbor.
No, they're going to tell you you're responsible for half of the total cost of the fence. And you object. So I don't have animals. It's a fence out state. I've got animals. You don't have animals. Make him fence his animals out. What?
You said fence out, it's a fence in state.
Yeah, we're fence in jurisdiction. That's right. Thank you. He's got livestock. Make him fence those animals in. I don't have to. Shouldn't have to pay for that. Well, it's an equal share statute. This is the rub under the Kansas statute. Okay. So what if a livestock owner shares a partition fence with a crop farmer or somebody that doesn't have livestock? What happens in that situation? Well, crop farmer doesn't want to share equally in the cost of building and maintaining the fence, which she fell right into that and said, I don't want to do this. A couple of principles here. If I go ahead and bear the total cost and my animals get out and eat her plants, okay, then I'm not responsible. It can bar her recovery of damages if livestock escape part of a fence the crop farmer was responsible for. She's responsible for half. She didn't pay for half. My animals get out, damage her plants, damage her vegetables. She doesn't have any recourse because she didn't participate in building that fence. And you can also be responsible for others for trespassing livestock damage. My livestock not only go through your property, they go onto somebody else. Well, it's because you didn't contribute to the cost of building the fence. You can still be held liable for that. So that can create a mess. Now, can she be forced to pay for an equal share? Yes. And this is where the statute is confusing to read. It's worded strangely. But it says you cannot be forced, this is the Kansas statute, you cannot be forced to build or pay for an equal share of a partition fence as a non-livestock owner if the adjoining tracts are used in common, okay, for the same purpose, such as crop raising, okay? Oh, well, I have livestock and you don't have livestock. So do we meet that requirement? No. What if I have crops and not livestock, and she doesn't have livestock, and I want a fence, and I approach her, I say, I'd like to put a fence up on the line. And she says no. Is she right in saying no? Yeah, because that property is used in common. It's the same usage, non-livestock usage on both sides of the fence. But once you get livestock on one side, crops on the other side, then the equal share rule kicks in. The fence statute in Kansas is very favorable to the livestock industry. Okay? I wonder who has a really effective lobby group in the state of Kansas. Okay? The livestock industry always has. Yeah. Well, at least used to. Okay, 2 requirements here. One party doesn't want the fence. We meet that requirement. She didn't want the fence. And we both use it to grow crops. No, I have livestock. Okay. All right. So she's going to have to pay for an equal share of the fence. So the statute only applies to relieve a landowner from the responsibility for sharing equally the cost of building and maintaining the partition fences when the land is used in common and the complaining party doesn't want the fence. Now, have we had any cases on that? Not really. We've had 2 Attorney General opinions on that. Okay. Okay. That's one of the most confusing portions of the Kansas fence statute. So we can't agree. We could negotiate a fence agreement, have it recorded. We could resolve the matter privately. Okay, there are various ways that Kansans over the years have figured out how to do that. Some of the old cases on this, back into the 1800s, did involve pistols, but that's not suggested as the proper approach. But if we can't come to an agreement, we can't resolve it privately, then we call the fence viewers. Who are the fence viewers? They're the county commissioners, or they're designees in the county where the fence is located. If the fence is on a county border, then this gets even trickier because now you have 2 sets of commissioners that are involved. The chairman of each county board, and if you can't agree, then a 3rd viewer is selected from the county fence viewers in the counties. and their decision has to be recorded in the land records of each county. Sometimes we do have fences that are on the county line. The decision of fence viewers has to be by majority vote. Now, the fence viewers can act as a board collectively, okay, as an entire board. It could be a board decision, or they may appoint any two of them to be the fence viewers. Now, in the vast majority of counties, how many county commissioners do you have? 3. How many do you have in Sedgwick County? 5. There are a handful of counties that have 5. The more urban counties have 5-member commissions. Most of the counties have 3. Now, how do you remember that? Basically, the good way to remember where the 5-member board counties are at is take a look at the map of the last governor election in the state of Kansas. The sitting governor only won the counties that basically have the 5 commissioners. That's it. Okay? The rest of the whole state, it's 3 per county. That's a rough approximation of how you remember that. So you're going to get Johnson County and Sedgwick County and several other counties, but that's about it. Okay? It's not exactly the same, but it's pretty close. Okay, now they act upon application of a landowner for review. You have to go request. You have to apply, you go to the county clerk, say I'd like to have a fence view. County clerk will give you the paperwork, you fill out the paperwork, and that's an application to have a fence view done. Now, the viewers only have jurisdiction over building and maintenance disputes. They do not determine where the location of the boundary is going to be. The only thing they will determine is what is she responsible for, what am I responsible for in terms of building or maintaining a fence. That's it, okay? They cannot order an existing fence to be moved. Why? That's a boundary issue. That's a legal issue beyond the scope of what county commissioners have authority to deal with by statute. So if we're dealing with a boundary issue, that's not county commissioners. If we're dealing with building or maintenance, that is county commissioners' jurisdiction. All right. After they come out and make a view, so you made the application, they come out and make a view, and sometimes in the more urban counties and newly elected commissioners, they have no clue that this is part of their job responsibilities. Now, there was a picture on the front page of the Topeka Capital Journal that's probably been close to 30 years ago of a newly elected female commissioner that was in high heels out in a cow pasture. I don't know if some of you may remember the picture. I cut it out. I saved it someplace. I can't remember where it was. And she was interviewed, and in the news story, she was saying, I had no idea this was part of the job responsibility. I saw it was on our list of things to do today, but I didn't realize I actually had to go out and walk in a cow pasture. And it's a pretty cool picture. But yeah, that's part of the responsibilities. So they come out and make a view and assign to each party. So they'll assign to her. I should get your name since I'm, what? Monique. They'll assign Monique her responsibilities, and they'll assign me my responsibilities in writing, and it should be an equal share of the total cost of building and maintaining or repairing that fence. And that decision is recorded in the County Register of Deeds office. Now, what if Monique is not pleased? She still is saying, I don't need a fence. It's a fence in jurisdiction. I don't need a fence. I don't agree with your decision. Can she appeal? Maybe. Again, it depends. If they are acting as fence viewers, so they've designated any two of them to be fence viewers, their decision is final, it's conclusive, it's not appealable, it's binding on the parties and all succeeding occupants of the land. That one's not appealable. So if they have selected any two of them to be fence viewers, you can't appeal their decision. This is a key point to remember. If they're acting as a board, then it's a board decision and your normal appeal rules apply in that situation. So if they have not appointed any two of them to act as the viewers, then any decision is deemed to be a board decision. That's appealable. So you get notice of appeal. Monique would file her notice of appeal in this situation on the board's clerk within 30 days, and she has to provide a bond and pay necessary costs. Oh, okay. Now, She loses the appeal. Still won't listen. I mean, this, you're the neighbor I just don't want to have. Okay? Neighbor still won't listen. What can I do? Well, the statute says the other party, meaning me, I can erect, repair, or maintain the entire fence and charge the non-performing party. I can send her a bill for her share of the cost of the fence, plus interest at 1% a month, and attorney's fees if legal action is needed to collect it. However, we have another case on this. This is the Kunze against Schwartz case from Riley County back in 2001. And at that point in time, my wife and I and our kids lived in northern Riley County. And I would spend several hours, it seemed like every Saturday morning for months, counseling one of the parties, which this is before it was in litigation, as to what the process was. Now, how many of you are familiar with the terrain in northern Riley County? You are. I mean, it's a jungle. It really is. It's rough. It's rough country. You get up north of Randolph, where we live near Randolph, you get further north, and it's pretty rugged. You got canyons, you got water, you got trees. It's really rough. And these people, Kunze and Schwartz, were adjoining ranchers in the northern part of the county in some really rough areas. And they both run cattle. It's two different cattle operations. So they need a fence. And we're not dealing with cattle and crops, so that we don't have that argument at all. It's just we have a fence where it's really difficult to build it. And one of the parties had to fence over a water gap. And during times of high water, the fence would always blow out. You get cows that go out all over the place. And the adjoining neighbor just simply refused to continue building this. He said, I'm tired of this, you build it. Well, they both have cattle. So these guys couldn't resolve the issue. There was a lot of bad blood between them. So they called the county commissioners. One of them makes an application for the commissioners to come make a view. The commissioners did come make a view. They did act as the board. So it's going to be a board decision. Okay, they made the decision. One party didn't comply with that. Said, no, I'm not going to build this fence. So what happened in that instance was the other party said, I want to go ahead and build it. My cows are getting out. We need a fence. So there has to be a fence. So he said, I need to go ahead and build this fence. And according to the statute, and he's asking me about this, and I'm looking at the statute. I said, the statute says if they don't comply with the order, the other party can build the fence. I said, keep good records, send your statement. And he did that. He sent the statement, and his neighbor wouldn't pay the bill. This thing ends up in court. And we got an interesting construction by the court of the statute that none of us would have guessed. And what they said is, yes, you call the viewers make a decision, neighbor doesn't apply. You can't just go ahead, according to what the statute apparently read, I thought, you can't just go ahead and send, I couldn't just go ahead and send Monique a bill. I have to call the county commissioners out a second time to make a second view to show them that the neighbor has not paid for the work that's been done, or that the fence is still out. I should phrase it that way. The fence is still out. They won't comply. So you have to make a second view to have them come out to see that, yeah, Monique she's not complied with the first order. Okay? So he said, oh, okay, after the second view, all right, we still have the problem here. You can now build and maintain the fence. All right, so I build and maintain the fence. Can I send her a bill yet? No. The court said the statute requires a third view by the county commissioners. They now have to come out and certify the work that you did and the bill that you're submitting to make sure that that is appropriate. And then, after that's done, you can bill them. 3 views. 3 views to get this done is what the court said. Never would have guessed that. That is not in the statute. That's just the way the court interpreted that.
You said Kansas is a fenced-in state.
We are fenced in.
And you're required to keep your animals fenced in. So why is it if you hit an animal
I'm coming to that.
Okay.
Yeah, coming to that. Okay. I was going to say hold your horses, but hold your cows. Okay. All right. So fence viewers can only require that a legal fence be built, that is, a legal fence in the county. Each county can have its own fence requirements as long as it's not less restrictive than state law. They can be more restrictive. But here are the basics of what is a legal fence in Kansas. If it's a barbed wire fence, then it has to have at least 3 wires. Now, most barbed wire fences have how many strands? A lot of them are 5 wires. Sometimes you'll see a 4 wire. Occasionally you'll still see a 3 wire, but they're pretty rare. But that's the minimum. That is legal. There are other types that are listed in the statute. At the discretion of the viewers, a brook, river, creek, ditch, and equivalent construction may be deemed to be a legal fence. How many of you, well, you know where Matfield Green is at? Have you driven a little bit north of Matfield Green? What type of fence do you see there?
I see a lot of barbed.
There's a lot of barbed wire, but what's unique there? There's a stone fence that's there. That is a legal fence. That is a legal fence. County commissioners can enact more stringent fencing requirements on a county-wide basis, as I mentioned. Now, it has to be a legal and sufficient fence. Oh. What does sufficient mean? It means it keeps in the animals it's intended to keep in. You're going to need a different fence if we're talking sheep, goats, if we're talking hogs, than if we're talking cattle. So it could be a legal fence, but it's not going to keep hogs in, or it's not going to keep goats in, for example. So it has to be legal and sufficient. So keep that in mind, or if we're talking other types of animals. A legal fence has to be sufficient. Always remember, having a legal fence does not mean that a livestock owner will not be liable for damage his animals cause if they escape. Not having a legal fence is negligence. So having a legal fence is the minimum standard, but it's not necessarily a sufficient fence for livestock. So it's a necessary but not sufficient condition, is what I would say, to have a legal fence. It has to be also sufficient. Clark against Carson was a 1961 case in Kansas that involved a legal fence that was deemed not to be a sufficient fence. And that's still good law today. You have to meet both of those requirements. It has to be legal, meaning it meets the statutory requirements. Then it has to be sufficient, meaning in its application, keeping the animals in. Okay? That's a key point to keep in mind, because I'll hear this argument 2 or 3 times a year. I'll get a call or I'll get an email. My neighbor says he's got a legal fence, but his animals keep getting out. Okay, it's not a sufficient fence. You have to have both conditions satisfied. So the issue comes up with animals other than cattle primarily, but it can come up with respect to cattle too. The point is that if a fence meets the requirements to be a legal fence, that's just the first step of the analysis. It has to be a sufficient fence also. Now, we get into the trespass issue, animals that get out. Okay? If livestock escape a fence that is in good repair, the owner is generally not liable. That's the rule in Kansas. General rule is you are not liable if your animals get out of a good, sufficient fence, legal, sufficient fence, and get hit on the road, cause damage to somebody else's person or their property. You're generally not liable. The injured party has to prove that you were negligent. Okay, that's the rule in Kansas. Yes, in the back.
So, we had I think it was a woman killed a few weeks ago or a couple months ago by hitting a cow on the road. Does that mean the cow's owner is not liable if the fence is in good repair?
Probably not. Cow's owner is probably not responsible unless the estate of the decedent can prove that the animal owner was negligent somehow. The burden is on the injured party to prove that the animal owner was negligent. So, what would be evidence of negligence? You left a gate open. Okay. You knew you needed a stronger enclosure, and you didn't do anything about it. You had a bad fence. Okay. So if you had a good fence, you had a legal and sufficient fence, it was well repaired, well maintained, okay, that's not an inadequate fence. So you'd have to show, all right, you left a gate open, okay, you knew the animals were out and you didn't try to get them back in, that's evidence of negligence. So the damaged party or the injured party or the estate of a decedent would have to show that you were negligent somehow. That's the rule in Kansas. Okay, I will tell you this. Insurance companies know the rule, but they will browbeat the livestock owner immediately with a letter saying you're responsible for our insured party. That one can go in the trash. I have seen so many of those. They know the rule. They're messing with you as the livestock owner. They're just trying to get you to pay before this goes any further. Know what your responsibility is. They have to prove negligence. If they just make a blind assertion, your animal is out, you have to pay. That's not the rule in Kansas. Okay, so you need to push back on that. Say, no, that's not the rule. And here's the rule. And what is your proof that I was negligent? That's the key point. Okay? It's not a strict liability type situation. So, and I'll come to a couple of cases here on that particular issue in just a moment. But let me go to the next issue. What if animals get into somebody else's property and cause damage? So this is not the personal injury type situation. This is damaging somebody else's crops, chewing up Monique's garden, those types of things. My animals get out, damage her property. What can she do? Well, she can pen up my animals. Okay? Well, she doesn't want to do that. She doesn't have a corral. She's got gardens. Okay, well, you can call the sheriff in that situation. Okay, but she can retain the animals until I make payment for the damages that my animals have caused, plus reasonable cost. This is what the statute says. And she has to notify me within 24 hours. She just can't hang on to my animals. Maybe I'm not around, I'm out somewhere. And she said, well, you know, if I hang on to these for several days, they'll destroy everything. I can get more money out of him. It doesn't work that way. You have to notify me within 24 hours. And once notice is given, can only hold them for 5 days without bringing legal action. Bringing should be legal action against the owner. Alternatively, what she could do is call the sheriff. And that's probably what most people will do. That's what she'd do. Call the sheriff. Sheriff takes the animals into custody and gives notice. I have 10 days to reclaim and pay costs. If not, then they're going to get sold at auction. Okay? All right. So if we have strays, that's a different situation because we don't know who the owner of the stray animal is. You notify the sheriff within 24 hours. They've got these stray animals here. I don't know whose they are. They don't have ear tags on them. Or if they do, I don't know whose ear tag they are. They're not branded. I don't know where they came from. And the party finding them gets what's called an adjuster's lien for their costs incurred in caring for and feeding the animals. Okay, you get a lien because then when the sheriff sells the animals at auction, that pays your lien. That you're going to get reimbursed that way. All right. Can you move livestock on a public roadway going from one pasture to another? Yes, you can. If they're under control, you have to keep them under control, but that can be a sometimes thing if you're doing that. If they do get out of control and they cause damage, then that is a strict liability rule in that situation. Okay, railroad fences, and I'm going to come back to a couple of other cases here in a moment. You don't have any responsibility as a landowner with respect to building or maintaining railroad fences. That is the responsibility of the railroad. Does anybody here have a railroad go through your property? Okay, that's the responsibility of the railroad to fence that off. They are responsible for damages caused to livestock because of a faulty railroad fence. Fault's not an issue. That's a strict liability rule. They can avoid that liability by enclosing their tracks with fencing. Okay, that's their job. Adjacent landowners can require the railroad to enclose the right-of-way with lawful or a hog-tight fence if it's hogs. Now, railroads can be difficult to deal with. They can be difficult to find who I'm supposed to be talking to address this issue, and I'm going to give you an inside baseball tip here in just a second as to how that gets done. Some states fine railroads for refusing to build fences. Other states allow the landowner to be reimbursed for cost plus interest for building a fence. This is the Kansas approach right here. But failure by a railroad to maintain a fence at a public road crossing makes the railroad liable unless the animals were on the track through the willful act of the owner. Okay. Willfulness on the part of the owner. That's going to be a pretty rare situation. Okay, now let me back up before I change gears here. Let's say you've got the railroad fence needs maintained. How do you get the railroad to maintain that fence? What office of the railroad? Let's say you're dealing with, what comes through here? You have Union Pacific Railroad?
UPRR, BNSF, and KNF.
BNSF, Union Pacific, and some short lines.
Okay,
Yeah.
yeah.
Okay. Who do you contact? The real estate office of the railroad. You need to figure out where that's at. For UP, on their lines in Kansas, where's that office at? Kansas City. Oh boy. If you get a short line, there's a short line that runs through southeastern Kansas, kind of comes southeast of Wichita and goes back to Pittsburgh and so forth. I can't remember the name of it. That office is in Pittsburgh. So for the short lines, it's going to be more localized. For the bigger ones, BNSF or UP is Kansas City. I think BNSF is also Kansas City. It's where their real estate office is at. Okay? Now, you're going to get the runaround. They're not going to answer the phone. They're not going to respond. They're difficult to find on email, and they may not respond to that. How do you get this fixed? Here's your inside baseball tip. Okay? You watch for the linemen to come up and down the line checking the track, and you go out and you talk to the lineman and say that, this fence needs to be rebuilt, or we have an issue with a grade crossing here. Would you write that up as a safety issue? The minute, and they'll do it, because that's what they get paid to do on those jobs. And the minute they write it up as a safety issue, that goes to the headquarters of UP in Omaha, and it trips the system. Safety issue, immediately the order goes out, repair it. Fence gets fixed immediately. Okay?
If it hasn't gotten fixed, how long should we wait?
How long should you wait if it hasn't gotten fixed? Depends on what your patient's tolerance level is. But that's the way you do it. If you can find the guys going up and down the track, checking the track, have them reported as a safety issue. They'll write it up. All safety issues go to headquarters. Headquarters will immediately, these railroads are so sensitive on safety issues, immediately the order goes out, fix it, whatever it is, do it, fix it. And they will get it done. I had a county commissioner in Kansas last summer, had that same issue. They had a fence issue and a road ditch and a culvert and a grade crossing issue. He said, we cannot get, this was UP, we cannot get this taken care of. I told him, handle it that way. He called me back a month later and he said, as soon as I saw those guys come through, I asked them to do that, and within 2 days it was fixed. And we had spent months on this issue. He said, it'll get fixed immediately if it's reported as a safety issue. Okay? I also have ways where I can tell you when the guys will be up and down that particular line.
Oh, I see them all the time.
Yeah. So you don't have to sit around and wait. I can get you that information too. So that's the little bit of inside baseball. All right, highway fences. Farmers responsible for maintaining the inner fence. The State Department of Transportation is responsible for maintaining the outer fence. You're going to see this along Turnpike, along I-70, along interstates. That's primarily where you're going to see highway fences. You also see it along some state highways in Kansas also. It's the land, also you get a weed issue with the land between the fences causing weed control problems. Now, what responsibility does the state have to the motoring public with respect to building and maintaining highway fences? Here's the question. Does the Department of Transportation in Kansas have the duty to build a legal and sufficient fence, just like a livestock owner would, or is their duty to just make sure some type of fence is there to obstruct vehicular traffic from entering a roadway at any given point? just to restrict entrance to a roadway where a road is at. Pardon me? Must be adequate, he says. Everybody agree? I see some saying, what's the purpose of a highway fence? Is it to keep animals in or cars restricted to access points?
The latter.
The latter?
Well, if we're a fence-in state, wouldn't it be the former?
See this? Yeah, their argument is we're not running cattle. Not our responsibility.
I mean, if you're doing, go ahead.
He's got it right. He's got it right here. They have to build a legal and sufficient fence. Let me show you the case on this. It'll come up here in a second. Let me get to this. What if we have a public road through a private pasture? We've got some of those, particularly in the Flint Hills. They may exist by the authorization of the county commissioners. They can permit a gate and a fence to be in place across certain public roads. Now, you can't authorize the locking of a gate that would bar the general public from accessing the road. So you have an auto gate or a cattle guard in those situations. Now, KDOT has a common law duty to keep the highways in a reasonably safe condition. So we're back to this highway fence issue. What does that mean in terms of the type of fence? In a reasonably safe condition. Well, here's the key case on this. Reynolds versus Kansas Department of Transportation. This involved a death. And this was Highway 69 coming south out of Kansas City, gets down into Miami County. And this was, now that's all 4-lane, pretty much all the way down to Pittsburgh, at least to Scott City it is. I think they finished it south of Scott City. But at the time of the case, back in 2001, the time of the accident was a few years before that, that was the 4-lane stopped, like Miami County, some places where it stopped. Then it was 2-lane the rest of the way. But this was in the 4-lane portion of that. And what you had on the west side of 69 coming south out of Overland Park, you have a cattle pasture on the west side of the highway, on the 2 lanes going south. Okay, 2 lanes going north are on the east side. Highway fence was constructed by KDOT on both sides here. It was built up and around a double box culvert. Okay, and what happened was the tenant on the cattle pasture on the west side fenced the mouth of the culvert, but the fence would wash out periodically and the cattle would escape to an orchard on the other side of the road. They'd go through the culvert, the double box culvert, underneath the road, underneath the median, underneath the other lanes on the other side, and come up on the other side, which was an orchard with a highway fence. There was no landowner fence, it was just a highway fence, and it was in bad shape. And so the cows would go all the way under, come up, and get out on the highway by virtue of that highway fence that was in bad shape. They got out on the highway, car hits them, lady dies. This is the wrongful death lawsuit. And the state is arguing, no, wait a minute, we had a highway fence there. It served its purpose by restricting vehicular access to the highway to the road that gave access to Highway 69. We don't have to build a cattle-tight fence. So that was the question. Does KDOT have a statutory duty to maintain cattle-tight fences, was the first question. And secondly, was KDOT negligent in not repairing a damaged highway fence? And this went all the way through the court system. And this is the Kansas Court of Appeals opinion. And the Court of Appeals said, no, KDOT does not have a duty to maintain cattle-tight fences. Highway fences, their only purpose is to control vehicular access to the roadway, not to keep livestock in. And so on the second question, KDOT was not negligent for not repairing a damaged highway fence. Negligent doesn't matter. They just had it there to restrict vehicular access to the roadway, and it served its purpose. And there was no evidence that the cows escaped other than through the unfenced culvert, and KDOT had no duty to fence off the mouths of the culvert. The trial court had decided this on behalf of the decedent's estate and it awarded them $1.2 million. The trial court, or the Court of Appeals, reversed that. It goes to the Kansas Supreme Court. Kansas Supreme Court reverses the appellate court, reinstates the jury verdict for the family, and said the state does have a duty to maintain highway fences to keep livestock off of public roadways. He had it right. Okay? That's the rule. Okay, the state was not terribly pleased with that, but the legislature has not changed the statute to reflect, to change that opinion. So it's not in the statutes, it's in the Supreme Court opinion. So it's part of the common law. Now, we had a cow vehicle accident a few years ago on I-70 out near Goodland. This is a couple from Indiana. You'll notice this is in a federal court, Federal District of Kansas, because the type of jurisdiction that was involved. They were from Indiana. They had been to the Denver Stock Show. They were coming back eastbound on I-70, trying to get back to Indiana. It's about 2 in the morning. They're rolling along about 80 miles an hour. The guy's got an F-150 pickup truck, and somebody, probably a semi, had hit a cow on the interstate, and it's laying there dead in the interstate. And he comes up on it. It's a black cow. It's dark. He's going 80 miles an hour. He can't avoid it. He sees it too late, rolls the pickup truck, is not killed. He and his wife were injured, but and there were some visibility issues. And you end up with claims against Cattle Company, which they traced the ownership of the cow to, and you had negligence claims, comparative fault claims, and this goes through a bunch of procedural issues, and they were denied summary judgment on the negligence claim because there was some issue about whether their gate had been left open to the pasture, who left it open. That was a question, so that's got to go to a jury. They thought there might have been an unknown trespasser, which happens if you have land along an interstate in certain locations. That can happen, and they think that's what happened here. But on the highway fence issue, the highway fence was in good shape. So KDOT did not breach its duty of care to have a legal and sufficient highway fence. What happened was they think there was some type of interior gate that was left open. The cows got access to a county road that led to the interstate. Got down an entrance ramp and just got, or the land near the entrance ramp, and got on I-70. So that one, I'm not sure what happened to that. That must have settled because there's no final opinion on it. But that was the most recent cow vehicle accident case that I can find for you, cite for you in Kansas. Okay, now let's talk about recreational use statutes. And if you have, you're starting to run a business on your property, what are some of the legal issues and what are some of the statutory protections that you might have for your businesses that you're running on your farm or your ranch property in Kansas? Well, Kansas has a recreational use statute. It's based on model legislation that was proposed back in 1965 by the Council on Governors, and the general purpose of a recreational use statute is to limit your liability, to provide you liability protection for entrants that come onto your property for a recreational purpose. So it limits the liability of persons that make their rural land available to the general public for recreational purposes. That's the whole purpose of a recreational use statute in general. And it includes a whole bunch of stuff in terms of the geography of the property and what's there, and includes a lot of activities that can be associated with that. So hunting and fishing would be common, hiking, picture taking, camping, picnicking, pleasure driving, nature study, all those types of things. Those activities on rural land are afforded the protection of a recreational use statute. What it means is that these recreational users are given no higher status than that of a trespasser. Okay, what duty do you owe to a trespasser on your property, an adult trespasser? Really none, except from willfully injuring them. Okay, so you can't sit on your front porch with your 7mm mag, and as soon as somebody tows across the property line, you can't shoot them. Okay, that would be willing and wantonly injuring someone. You can't do that. All right. Other than that, you don't have a duty to warn. You don't have a duty to disclose of dangerous conditions on your property. You can sit on your porch and watch them, knowing that they're headed toward a pasture that has a very cantankerous bull in them, and enjoy the view. You don't have a duty to warn if they're an adult trespasser. Now, if they're a child trespasser, that's a little bit different. Okay, child trespassers are treated a little bit differently under the law, but we'll hold that for a different discussion. So you're not shielded from willful or malicious failure to guard or warn against a dangerous condition, use, structure, or activity. So willful or malicious failure. You have to, my example here of sitting back knowing what this trespasser is going to walk into, that could grade into willful maliciousness, especially if it's a neighbor that you hate that you see is going to get injured. Don't do that.
So if someone comes on my property, tries to steal one of my cows or
Mm-hmm.
one of my lovely alpacas, it would be against the law for me to go after them?
Okay, her question was, if somebody comes on her property and tries to, and you can see it, they're trying to steal one of your alpacas. Am I saying you can't do anything about it? I'm saying you can't injure them in doing that. Mm-hmm. You can certainly pick up the phone and call the sheriff and get the sheriff out there. You can warn them, okay? You can do those things, but you can't willfully or intentionally or maliciously injure them. Mm-hmm. Now, the Model Act does not provide liability protection if you charge a fee. Kansas changes that. A rural landowner can charge a fee. An urban landowner can't. Well, you can, but you're not going to get the protection of the statute if you do. If you're a rural landowner, you can charge a fee and still get the protection of the statute. Okay? That requires also very careful drafting of release forms. I'll come back to that issue in just a bit. There are other limitations that could apply. Residential and family situations, livestock viewing at a county fair, and these are all based on cases that I have read and write about. Maybe the statute doesn't apply with respect to family members. Maybe it doesn't apply to a person viewing hogs at the county fair in western Nebraska, which is the case I'm referring to. The lady was viewing livestock at the county fair and a hog bit her on the backside. So she sued the University of Nebraska Extension, because who operates the fair? Mm-hmm. Yeah, okay. And they said, well, there's no protection in that situation. Liability might be imposed if you're acting as a tour guide. Now, this is the bizarre Sally against Stewart case in Iowa in 2012. This case, now this one's going to be near and dear to your heart if you're thinking of doing or you have an activity where you're having the public come to your farm. This is a dairy farmer in Iowa that for the previous 20 years had always invited the local kindergarten class to come out to the farm to see how he operates his dairy. Okay? There was one of the mothers that accompanied as a chaperone. Okay? And as the court described it, this is not me making this up, this is the court, she was well fed, and she was above the weight limit for the stairs in his barn. Okay? He and his son told her, seeing her condition, don't go on the stairs. We'll take the class to the hayloft. We'll take them downstairs. You stay off the stairs. You just wait here. We got it under control. What did she do? Got on the stairs. Stairs couldn't hold her weight. She collapses, injures herself, sues him. And the court said he lost the protection of the recreational use statute because he was acting as a tour guide. I went nuts when I saw that pen. I wrote a piece on that. I did radio, I did TV on that. I said, this is ridiculous. I rewrote the statute, handed it to a couple of senators in Iowa that I knew, they were my friends. The fortunate thing about this is that the Supreme Court in Iowa made the mistake of rendering their opinion in February while the legislature was in session. Before the session ended, the legislature had reversed that and obliterated the opinion. Just completely abrogated the opinion because they rewrote the statute to make sure you still had protection even if you were a tour guide. So that's one of those where you can kind of stick it right in the eyes of the Supreme Court justices in that one.
Does that include somebody coming in by apiary or bee yard if they get bee stuff?
Yes. It applies to, it depends on what's the purpose of them being there.
They don't belong there. There is no purpose to them being there, but they do.
So they're a trespasser? Okay, if they're a trespasser, then you have no duty with respect to the trespassers.
I'm showing them off too.
Okay, if you're showing the bees, then that is an activity that's covered under the recreational use statute. So it limits your liability, and you're only responsible if you wantonly or willfully injure them in that instance. Okay, so it really limits your liability. Depends on what purpose they're there for. Okay, so that was the weird case of the tour guide situation in Iowa. We don't have a similar case like that in Kansas. I think the statute would cover us anyway, but the Iowa statute has been retooled. As I said, that was decided in February. The legislature was in session at that time. They abrogated it, get this, unanimously in the House and the Senate. There wasn't a single vote against abrogating the Supreme Court's opinion. You talk about a smackdown. That is a smackdown, big time, okay? So Supreme Court opinion is not the law of the land. It's only the law of the land if you allow it to stand. And that's the key point here. The people write the laws, not the courts. And here, the people of Iowa rewrote that one and said, you're nuts, court, out. We're going to override you. And the governor signed the legislation into law, restoring recreational use immunity in Iowa in accordance with the statute. And I just thought it was such a breach of what the statute actually said that apparently the legislature agreed. Okay, so here's this was the Iowa statute. I'm going to skip that in the interest of time. Now, what about release forms? Can you have people that come on your premises sign a release form, and that release form will be valid to relieve you from liability? Again, another quirk in Iowa, the answer is no. That document has to be negotiable. It has to be written in very careful ways. I'm not aware in Kansas of anything close to what the Iowa courts have said, but it's not going to hurt you. You can have a release form, but I wouldn't rely totally on a release form saying, well, yeah, you injured yourself, but you signed a release form here saying that you wouldn't hold me liable. You can't relieve yourself contractually of liability for negligent acts, for example, or willful acts, those types of things. You can't do that. You might be able to give yourself some liability protection by a release form for other types of situations, but be very careful with respect to the use of release forms. Okay, so they have to be very carefully drafted. They need to be clear on what you're seeking a release from liability from. So the person who is giving up their rights by signing a liability release form must know what they're giving up. Okay, that's what that means. Must be unambiguous and explicit, not violate public policy, whatever that is. Okay. No disparity of bargaining power. Go through the document with the individual. Tell them, take that to your lawyer, have your lawyer counsel you with respect to this before you sign it. So no disparity in bargaining power. Now in Iowa, a parent cannot sign a release form on behalf of a child. That won't work. I'm not aware of a Kansas case that said the same thing on that, but in Iowa you can't. And any uncertain terms will be construed against the party that is providing the form, that drafted the form. So if this is a form you're requiring guests to sign and you get sued and the court says, well, that's an uncertain term, it's going to be construed against you and in their favor. Okay, so the lesson on this one is have these drafted by an attorney that is familiar with how these things need to work and is familiar with your particular operation and what you're doing on your farm or on your property, and have it tailored to your situation, because these have to be done precisely. Claims. Yeah, I'll talk about insurance in a moment. And yeah, you need to have adequate insurance. Claims based on negligent supervision generally are not covered by the Recreational Use Act. And that is a case out east in Maine. Negligent supervision. So I'll come to this issue in a moment about any employees or staff that you have, or maybe you don't, but what are your responsibilities in terms of supervising people that are on your property? Okay. You can't be negligent in that and receive the protection of a recreational use statute. Now, equine, let me just throw in horses here. Are there any horse operations here? Okay. Kansas has an equine Liability Act. All right. Now, Equine Activity Liability Act. These are designed to encourage equine-related activities by limiting your liability in certain situations. So the typical requirements here, and there's going to be a tie back into this statute in just a moment, with respect to the signage issue. You have to have particular language in contracts, liability release forms and waivers, and signage. Okay? And signage has to be appropriate. All right, so I'll skip that. I'm going to go to agritourism. Kansas also has an Agritourism Act that's a little over 20 years old, or right at 20 years old. And the statutes across the country vary. They can be a zoning type statute, it can be a limited liability type statute, or it may be a statute that requires, in addition, postage of warning signs. Okay? The Kansas statute requires certain types of signage, and it does provide some limited liability. It's not a zoning type statute. Okay, so agritourism, what is it in general? What is agritourism? Well, it's a combination of agriculture with tourism. It's another income stream for your farming activity. A lot of farmers and ranchers find that a way to generate more income. And that's going to be a big issue, particularly this year. What is USDA projecting for net farm income to be this year compared to last year? Have you seen it? Down 24%. So you're going to be looking, a lot more farmers are going to be looking for additional ways to generate revenue, and using the unique aspects of your property might be one way to do that. So if you can combine agriculture with tourism, might be a good way to do that. It's any activity that allows the general public to enter the premises for recreational, entertainment, or recreational purposes. Generally speaking, that's what agritourism is. So farming and ranching activities, historic, cultural, natural attractions, and you always have to make sure that you're in compliance with local laws. Okay, any local laws that apply, you have to be in compliance with those local laws and regulations. So know what those are before you start any activity, or if you already have. Make sure you check with local authorities. What are the local rules? What are the local regulations that might apply to me? What licenses do I have to be able to do what I want to do on my property? The Kansas Agritourism and Promotion Act was enacted in 2004. There's your statutory cite to it. It's in Section 32 of the Code, Section 1430, subsection 1430. You need to register your business at no cost at travelkansas.com or travelks.com. That's good for 5 years. Then you can renew it every 5 years. There's no cost to do that. But by registering your business, you receive several benefits. So you register it with the state, and you receive several benefits. You get access to free promotion by Kansas Tourism. They will promote your business for you. Now, in addition, you should have your own website, do your own marketing and those types of things, but the tourism division will promote this for you for free. You'll have social media pages, and you'll get a layer of limited liability. So those are the three benefits of registering your activity with the state. Okay. Marketing, social pages, social media pages, and limitation of liability, if you're registered and you have appropriate signage. Now, this statute on the signage issue is going to take you back to the Kansas Horse Council. The signage can be purchased from the Kansas Horse Council. And you need to tell them what your activity is on your premises, and they'll give you an appropriate sign. Okay? But that's how that's done. And you can go to their website. The protection you get under the agritourism statute is protection against inherent risks of a registered agritourism activity. So what's an inherent risk? It depends on what the activity is. What's an inherent risk of horseback riding? Getting thrown off, getting kicked, bit. Slipping saddle is an inherent risk. There are court cases on slipping saddles. What is a slipping saddle? How many of you have ever saddled a horse? What does a horse tend to do when you saddle it up?
They don't stay still.
And then you get on the horse and you start riding, and what do? Well, they start breathing, and now it's loose. And you end up, if it's not put on properly, you have a slipping saddle. And the courts have said that there are numerous court cases on this. Particularly, a couple of them I can think of involved operations out in Wyoming. And the court said, look, the slipping saddle is an inherent risk. You're basically deemed to assume the inherent risk of the activity you engage in. Okay? I was on, has anybody ever been on the Snake River in Hell's Canyon? I was last year. I did a 2-day tax seminar for CPAs in Boise, and the partners wanted to take myself and my wife to Hell's Canyon to raft up and down the Snake River in jet boats. 3.5-hour drive from Boise to get to Hell's Canyon. Hell's Canyon is on the border between Oregon and Idaho, up toward Washington. It's almost to Washington. And Hell's Canyon is much deeper than the Grand Canyon. So you're way down in there. And as we were going up that Saturday morning, I had lectured all day Thursday and Friday, and we're going up on a Saturday morning early. We get picked up at our hotel at about 5:30 in the morning. We went to one of the partners' homes about an hour and a half out of Boise on the way to Hell's Canyon, had breakfast there. He's telling me at breakfast, he said, now, this is safe. There's only been a few people over the years that have lost their lives. What are we getting into here? And by the way, when you get there, the guy that's going to run the jet boat is going to require you to sign a liability release. Why didn't you tell me these things before I agreed to do this? I said, oh, they're really good. I mean, he hasn't lost anyone personally, but there have been other people that have been lost in the rapids. But this guy's really good. He trained in Alaska. And when we saw him, he looked like Mountain Man Jack, and he had adequate training. He was really good, and we had a great time. But some of those rapids had 20 to 25 foot drops, and you had to work your way through them. Big rocks and big boulders, and but it was fabulous. We're going to do it again this fall. So I've got that same seminar coming up. We're going to do it again. But that was great. But he said, yeah, you've got to, what's an inherent risk of being in a jet boat on the Snake River and going through those rapids with the big rocks? Okay, an inherent risk depends on what the activity is. That's the point I'm trying to make. So with horses, it'd be a slipping saddle and getting thrown off and those types of things. Yeah, it just depends on what your activity is. But you still should, you're still responsible for negligence, intentional acts, injury arising from known dangerous conditions that you don't disclose to entrants on your property. Okay? You need to disclose those. You probably have a duty to rectify that condition. And you still should have liability insurance. That is heavily, heavily suggested. Have your own liability insurance. Talk to your insurance agent to determine for your activity what would be an appropriate level of coverage. Don't rely on your homeowner's insurance to cover you for this type of a pursuit. If you've got a comprehensive farm liability policy, don't rely on this for this other type of activity for which you're receiving payment for. Why? Because there's going to be a clause in a homeowner's policy and a farm comprehensive policy that says it excludes non-farm business pursuits of the insured. That's going to be the tag language. Non-farm business pursuits are not covered. So what do they think this kind of stuff is? It's a non-farm business pursuit, even though it's agritourism. It's not production agriculture. It's not an activity where you're getting income from raising crops, raising livestock. So it's a non-farm business pursuit of the insured, which is excluded from your policy. So you need a separate rider to cover these types of activities. So you need to talk with your insurance people to make sure that your activity is appropriately covered. Okay. All right. Now again, the Agritourism Promotion Act in Kansas does provide education and resource opportunities, and it doesn't have any impact on zoning. There's no impact on zoning. So in other words, it doesn't make it ag if it's not already ag. So you can't go to your county and argue for rezoning because now I'm doing agritourism and I'm registered under the Agritourism Act. No, the Agritourism Act says no impact on zoning. Even if you have a registered ag activity, it's not going to change any zoning designation. So if it doesn't make it ag if it's not already ag. Got that? Some have tried that. I tell them every time, no, that will not work. Why? Because the statute specifically says it is to have no impact, if you're registered under the Agritourism Act, on your zoning classification, your existing zoning classification with the county. Okay, let's talk about pesticide drift. Yes?
So, if, say, there was a sunflower field, and, you know, some do that, you can walk into it, maybe as a agribusiness tourism,
Sunflower field,
or
right?
maybe not. Maybe somebody just sees a pretty field and walks out into it,
They want to take pictures.
in a badger hole, breaks
Yeah.
a leg.
Yeah. Well, were they an invited guest or were they trespassing?
They were trespassing.
If they're trespassing, we're back to the issue of you don't have any responsibility. If they're an invited guest for which you're, whether you charge a fee or not, if you're inviting them to come look at your sunflowers, have pictures taken, those types of things, and they step in a badger hole and are injured, then that's a different story. The question is, did you invite them or not? If you didn't invite them, no liability. Okay? If you invited them, then you've got to make sure that those holes are taken care of. You should. Or at least warn where they're at. So it depends on their status as they come on the premises. Okay? All right, let's talk about pesticide drift. Aerial crop dusting. Okay, has anybody done this? Anybody been affected by aerial crop dusting? Are you strictly liable if you have pesticide drift onto somebody else's crop? Say you've got an organic producer that can't have any pesticides on their crops, or you've got trees, you've got gardens. You're supposed to be crop dusting this field over here. It drifts over onto a neighbor. The rule in some states is it's strict liability because that is deemed to be an ultra hazardous activity. That's not the rule in Kansas. The Kansas rule is that you have to establish negligence. So the general rule is that it is an inherently dangerous activity subject to strict liability. If you cause damage, you're going to be responsible. Okay, that's the general rule. That's not necessarily the rule in every jurisdiction, however. Okay, now we can move forward on this. Let me talk about Langan versus Valicopters, which is a 77 case out of the state of Washington. And in that one, you had organic farmers adjacent to a farm that was being aerially crop dusted. You had drift onto the organic crops, okay, which is a big no-no. You can lose your certification, major problems for an organic farmer. And the question was, what's the liability rule? Let me back it up one more here. Okay, plaintiffs or Langans are organic farmers. They sell their produce to organic food buyers. The defendant, Valicopters, is a crop dusting operation. Land adjacent to the plaintiff's land was sprayed with chemicals. The spray settled on their tomato, bean, garlic, cucumber, and artichoke rows, and they sued. And the question was, are we going to determine liability based on strict liability or based on negligence? Does the injured party have to prove the 4 elements of a negligence case? You owed me a duty not to spray my stuff. You breached the duty. The breach of the duty caused my damages. Do you have to show all that stuff, or do you just have to show that you were damaged and they are strictly liable? That was the question that was presented by the court in this situation. And here they applied a strict liability rule. They said strict liability. Plaintiffs were, look at the balancing of the equities, as the court said. The plaintiffs were eliminated from their market. Okay? They had the chemicals on it. It wipes them out of their market. They can't sell that as organic anymore. And the burden on the company itself was not very great. The plaintiffs would never be able to sell their crops to organic food buyers. The defendants would continue to profit from the further application of pesticides. And the court said the only way we can balance the equities is to make the company responsible. So that's how the court out in Washington in 1977 handled that situation. Some courts will also limit the application of that strict liability rule if the plaintiff is abnormally sensitive to the defendant's conduct. Okay, the abnormally sensitive plaintiff. Foster against Preston Mill is also a Washington case. And look at this one. You had dynamite blasting operations on a farm that killed or that caused the female mink of Foster's to kill their young, because that's what mink do. Mama mink, when they get upset, they cannibalize their young. The blasting upset them, destroying this mink farm's mink population, costing tremendous amount of damages. The blasting operator was not strictly liable. Now, this is the same court that said that Valicopters was strictly liable. Why no strict liability rule here? How am I supposed to know that mama mink are going to eat their young? How could I possibly know that, is what the court is saying. That's an abnormally sensitive plaintiff. Okay? No strict liability rule in that situation. You have to show negligence. The injured party would have to show negligence. All right. Now, this can also come up with the application of GMOs, or the application to GMOs. Pollen drift could be analogous to pesticide drift. You see the issue there? Pollen drift can be analogous to that. So what would the damages be? Again, loss of organic certification could be the issue. Costs associated with breaches of identity preserved contracts. In other words, I'm growing produce or a crop that is certified non-GMO, and I have a contract, an identity preserved contract, to sell that to a buyer that's going to get it into a market that will not accept GMOs. So when I sell that commodity, it's going to be tested for the presence of GMOs. If it's clear or within a tolerance level, then it's good. If it's outside of a tolerance level, then I'm not going to get paid, or I'm going to be penalized. And it's not going to go into that market that I was supplying. So do I have recourse against my neighbor whose pollen, GMO planted crops, pollinated and drifted over into my crops and caused my damage? That's synonymous with the other issue that we just talked about on pesticide drift. So my cost would be I lose my organic certification, or I incur costs associated with my loss of my identity preserved contracts. Also, the farmers with property onto which drift of GMOs occurs, me, for example, if I'm raising non-GMO crops, I could get sued by the companies such as Bayer, who bought out Monsanto, because they own the intellectual property rights to the seeds that farmer bought, and I didn't have a license to have that technology present on my property. I could get sued. And that has happened because of the drift. Okay, so now you got three parties that are involved here. If I get sued, I'm going to countersue the farmer for not keeping that technology on their property. The technology owner sues me for the presence of the technology, and it's an absolute mess of a triangle. And those cases are out there. Okay? So you have to be cognizant of that. Noxious weeds. This is an issue for everybody in all landowners, and if you need to be aware of this issue. Noxious weeds. Do you know what the noxious weeds are on the state list and in your counties? Because the county list can be different. So I throw that in there, and I think in the interest of time, I want to move on to some business plans here. But I do list the common noxious weeds and the responsibility to control noxious weeds in Kansas. And then I have a little bit in there on nuisance. And we've got a major nuisance case that's before the Kansas Supreme Court right now, coming out of Phillips and Norton County. And we'll see what happens with respect to that. But let me go on to the last portion of the discussion, and that's more of the business plan type situation. So let me see if I can find that real quick. Okay. Oh, that previous slide there on public nuisance has a picture on it. Anybody recognize where I took that picture at?
No.
I had spoken that day, all day, downtown New Orleans. And my wife came and got me when I finished about 4:30 and said, you need to come see Bourbon Street before it gets dark. That's Bourbon Street. Anybody ever been on Bourbon Street? Yeah, we walked that before dark, and within a half hour, with my wife on my arm, I was propositioned twice. There's no hesitation on Bourbon Street. I'd hate to see what it's like at dark. Man, they talk about bold. Goodness. Okay, but I list that as a public nuisance. That's my slide for public nuisance. Okay, creating a business plan. This is what I want to conclude with today, creating a business plan. All right, for your own operations, how are you going to be competitive? How are you going to make money? I assume you are interested in doing this because you want it to be profitable. You want an additional income stream. Okay? Not very many people enter into these things with the idea, I want to lose money. Okay? So, no. Well, how will you differentiate yourself? What are the characteristics of your property that are different from other people's property? What do you have that's unique about your property or unique about your skills and your activities? You raise bees. And what?
And birds.
And birds. I don't want to raise bees. I have property where I have a beekeeper. I rent it out to a beekeeper, and he explains them to me, and I said, you have fun with your bees. I'm staying away from the bees. Okay? So what unique characteristics do you have with your property or yourself? What's on your property? Do you have an empty farmhouse that could be a bed and breakfast? Do you have a pond? Fishing activities. Buildings. Do they have unique historical characteristics? Crops, livestock, geographic features. Do you have woodlands? What do you have? What do you have to work with? That's the question I would raise there. And then what's your appropriate entity for your business? Do you need an entity? Do you want to put it in a trust? Do you want to put it in a C Corp, an S Corp, an LLC? Talk to your professionals with respect to that in terms of what it gives you in terms of a tax advantage or a liability advantage. Employee agreements. Are you going to have employees? If so, do you need to train them? Well, you do if you have employees. Okay? If you're going to have people working for you, do you have a manual put together as to what your expectations are and what the obligations are? Will there be sponsorships or partnerships with other people? That kind of ties into the marketing aspect of things. Staffing, employees manual. Do you have training that needs to be done? What's the condition of any buildings you're going to have people from the public coming into? You need to make sure your buildings are in good shape. Restrooms, parking, landscaping, dealing with the holes that might be out there, making sure the landscaping is appropriate. You want to create an atmosphere that non-agricultural people really like. They want a special feel when they come to your property. So you want to create that atmosphere. That's part of all marketing your operation. Any fees that you charge, you're going to have an entrance fee or are you going to have an activity fee? Are you going to have both? You want to think that through. There are ways to differentiate with respect to fees. Collecting and paying state sales tax. Oh, okay. That's a pain. Okay, collecting and paying state sales tax. You really need to have an accountant as well as a lawyer to help you along. An accountant or a CPA can be really good in making sure you stay straight, particularly if you have employees and you're going to have taxes withheld and you're going to have to pay employment tax and then sales tax. You need to have somebody handling your books for you. If you don't feel comfortable doing that, make sure you have somebody that is. Okay? Project your startup expenses and your income. Are grants available for what you're doing? Are you familiar with what state level grants might be that are out there based on what your activity might be? Know your applicable regulations and licensure requirements. Put a marketing plan together. Make a connection with the state tourism office. Now, when you register your business, that's your initial connection. Get to know those people in the state tourism office. They can be very helpful to you. I mentioned collecting and paying state sales tax and the need for a good accountant as well as a lawyer on that one. Okay? We left like 3 minutes for questions, but those are the basic points of building a business plan. We talked about a whole bunch of liability issues. Your fence issues are going to come up. Your pesticide drift issues are going to come up. Nuisance issues, perhaps, depending on what the activity is, could come up. All those associated issues. If you have unique crops, do we have pollen drift issues? And then putting that business plan together and making sure it all fits. Those are just kind of a summary of what the major issues would be on that business plan side of things. Good idea to get an accountant and a lawyer in your working for you on this, because you can really get crosswise with the state quickly, particularly on the tax side of things, and it can consume you. You don't want that. Okay? And creating the appropriate entity, drafting of liability release forms, you need competent professionals to help you with that. Yes, it will cost, but it will be cost effective in the long run for you. Okay? Whenever you have questions, feel free to contact me. There's my contact information. I think it's still on the screen. And feel free to send me an email. That's the easiest way to catch me. And if we need contact for, I'll give you my cell number so we can talk. But use me as a resource, that's fine.